putting a dollar value on a personal injury case where someone's injured or killed, paralyzed, anything like that is never a science. It's always an art. It's never easy to look through, figure out exactly what something's worth. You know, people that do it for a living can study it and come to different conclusions. But there are a couple of factors that tend to be consistent in all of them that you need to look at in order to figure out exactly how much any particular personal injury case might or might not be worth, whether it's yours, a loved one, or someone that you know. The first factor is kind of obvious: how bad someone's injured. You know, you always see where people advertise, you know, attorneys advertise, oh, you know, $2 million verdicts, $2 million settlement, whatever it is. But really, the question that has to be asked along with that is, what are the facts of a particular case? You know, some cases are worth $1 or $2 million. Some cases are worth more. I've seen a lot of cases, and I've handled a lot of cases. Some of the cases where, to this day, I feel like I've done my best work on weren't the $1 million judgments. It's, you know, $10, $15, $20,000 judgments or settlements that I handled earlier in my career, or verdicts, where, you know, the facts, they weren't obvious. It was a tough case. It was the kind of case that could have gone either way, depending on how a particular jury looked at it. And I see that a lot of times with some other attorneys too, that do just a great job, particularly young, newer attorneys that aren't necessarily handling gigantic cases. And so, you know, people, it always feels good to get a big verdict or a big settlement. I'm not disputing that. But, you know, anytime I get one, generally, I've never had a, you know, what I call a big settlement over $1 million or more and felt that it was anything but that's exactly what it should have been. Like I've never had a $10,000 case where a jury just came in and gave $1 million. You know, you see $1 million anything, you know, a good lawyer can play a role in that, but the facts matter a lot more. And I think that's obvious. Someone in a wheelchair for the rest of their life, that might be $1 million case. Somebody who got banged on the arm and it's a little bit sore and their car scratched up and needs a paint job, that's not going to be $1 million case. The other thing that in a lot of these cases needs to be looked at and really studied, you know, particularly in cases that are a little bit more in the middle, are no matter how bad the record shows that the person's injured, what kind of diagrams are you going to have? What kind of animations? What kind of pictures are you going to have to be able to go through it piece by piece and show the jury exactly what happened? You know, right or wrong, we live in a world where people are generally, you know, aware that there's a lot of frivolous lawsuits being filed. You know, people get whiplash. They don't have any kind of way to show that. By the way, whiplash is real. I mean, there's people that have it for the rest of their lives. But that's it. Anytime you're dealing with an injury and you can't actually show a jury, here's what happened, here's how it affects it, you know, your case just isn't worth as much as if you were able to go through and systematically show step by step, you know, here's where the spine's messed up, you've got some impingement here, that affects this, this, this. What you can see right here on the chart directly corresponds to the injuries that the person's talking about and was talking about before the X-rays, MRIs, whatever it might be, even came back. Another thing that's really important in determining how much a particular case is worth, particularly, for example, say a truck wreck case where a truck runs into somebody, causes them some pretty serious damages, is, are we talking about a sympathetic driver making a mistake, or are we talking about a company that systematically just doesn't care? In Texas and in most states, there's something called respondeat superior. And basically what that means is that a company is on the hook for anything that their employee does. So if a driver, while they're driving for a company, causes an accident, the company's on the hook. But generally speaking, if you're talking about significantly sizable settlements or verdicts, having a driver who was tired, sympathetic, nice guy, admits he made a mistake, isn't going to inspire a jury or a judge to say, yeah, let's give this plaintiff millions of dollars. So an attorney can't just rely on respondeat superior. You have to go further and see, is the company itself at fault? And the three main ways that a company can be at fault is negligent training, negligent hiring, and negligent supervision. Negligent hiring is hiring someone that shouldn't have a job. For example, in a truck driver, is this truck driver been in a bunch of accidents? Is this truck driver shown a history of drug and alcohol abuse? Is this truck driver demonstrated that they're a hazard to every single person on the road? And did you either not look into it, or did you look into it and not care because you were able to pay him, say 50 cents less an hour than a reputable company would pay their drivers? Then they're not going to hire this guy. And also negligent training. A truck driver that doesn't necessarily know every single rule in the rules of the road, for lack of a better term, is going to be, generally speaking, pretty sympathetic. Anyone can get, I messed up. I should have been a little further back. There's all sorts of variations on that. But the question is, what's this company doing with training? Is the company doing training? Does the company have just a systematic indication that they don't care, that they don't want to waste time training? They need to get their drivers on the road. It's going to squeeze out a little bit of extra money, and something bad's going to happen, but that's just life. We need to do everything we can to make sure this bottom line's as good for us as possible, and we don't really care about safety, and it happens. And proving it's not always easy, but you'd be surprised. You get emails, you get texts. A lot of people get real sloppy. A lot of people get real comfortable with what they text and what they email. And also a lot of times people that used to work for the company but don't work anymore. Ideally because they got fed up with the lack of safety practices, but really for whatever reason, if you're no longer working for that company, a lot of times you're a lot more honest and a lot more forthcoming. And even if you are working for the company, the question is, how much are you going to lie for the company? If you've got a company that really doesn't hire very high quality people, doesn't train people very well, doesn't supervise them very well, it's probably not a company that's going to make somebody want to get on the stand and lie for them. Generally speaking, if a company is cheap and doesn't care about safety, they're not always treating their employees very well. Negligent supervision is another way that, that even if they hire someone, even if they give them kind of good training, you got to keep an eye on what's going on. If you're a company, you're responsible for putting safe drivers on the road. I mean, a truck is extremely dangerous, and so you need to supervise them properly. And you need to dig in. As a lawyer, you need to dig in deep and figure out what exactly are the supervisory practices. I mean, if it's a company that's doing good hire, if it's a company that's doing good training, if it's a company that's doing good supervision, well, good for them. I mean, that's going to affect your settlement values, but you need to know. It's your job to dig in there, figure out what's going on, and you need to know. Damages obviously don't get calculated like a computer. Human nature plays a part. The insurance companies, and in Texas, generally speaking, it's an insurance company handling the defense, but the jury will never know about that. In some states, insurance companies get sued. The jury knows that there's an insurance company involved. In the state of Texas, it'll be whoever got injured, plaintiff versus defendant driver and defendant company, generally speaking. It won't say versus whatever insurance company. And you can't bring that up to the jury. The theory being, well, it doesn't matter who's paying based on the damages, and it does make some sense, and it does seem fair. That said, the defense attorneys in the insurance companies do a pretty good job of giving the impression that this is just some, the driver's just some poor guy trying to make a living, which a lot of times they are. I mean, that's usually pretty sincere. But they'll always, if they can, present the trucking company, oh, this is some mom and pop operation, we're barely struggling, no way we're going to be able to pay this. So it might be true, it might not. And they're going to do everything they can to give that impression. So as an attorney, you always have to be aware if they're going over that line. And if, for example, they can't just say, there's no way we'd be able to pay a judgment. If even $25,000 is going to bankrupt us. Well, if they come out and say that, then you're certainly entitled as a plaintiff's attorney to come say, well, hold on. First of all, you've got insurance. Second of all, y'all are bringing in $3 million a year, probably more. It looks like up to $5 million if you really look at these. And so now the thing is, judges are very nervous about letting that sort of evidence in, as far as, because they don't want cases to be tried based on who the defendant is, how much money they have. And that's pretty reasonable. So if you've just, as a plaintiff's attorney, you've just got to have that case law ready, and you've got to know where to find it. If in fact somebody gets on the stand and tries to kind of, doesn't just ignore it or doesn't just show up looking poor, but actually says, yeah, we're real poor, we're not going to be able to pay this judgment, you've got to be ready to make sure that that judge feels real comfortable knowing that, yeah, it's okay. We can show that attorneys generally call it opening the door. If one side gives a false impression, the other side's allowed to correct it. And so as a plaintiff's attorney, that's your job, not just to know how to do it, but be ready at an instant to show that to the judge, and also let the judge know, hey, I'm on top of things. I'm not trying to get you overturned anymore. I don't want to get this verdict. I want to get verdicts I can keep. I don't want to make you look like you're making wrong decisions. And I don't want my clients to have to go back 3 years from now to square one. The other thing that it's important to keep in mind is where a case is held. And it's not always simple. It's not always straightforward. And there's two sort of issues in this. One is called forum and one is called venue. And a lot of times you'll hear them discussed interchangeably, but there are some very important differences that you need to be aware of. Forum basically means what state a case is in. And it's what's called a jurisdictional question. It's something that it's a lot harder for a defendant to waive. So a plaintiff really needs to make sure they're absolutely confident that if you're suing somebody or a company in a particular state, that's an okay state. I mean, if it's a trucking company from Ohio and they've never had any dealings with Texas and the accident didn't happen in Texas, you probably can't sue them in Texas. Now, there's all kinds of exceptions that any good attorney is going to look at, but it's something to be aware of, that the state laws can vary wildly, particularly on different kinds of cases. And so you need to be aware, if you have a choice of different states, which state is the absolute best to do it. And you also have to, if you're an attorney, you have to have integrity. And you can't just sue someone in your state because it's more convenient for you.
Now, different, but obviously pretty similar to forum is a question of venue. Venue is what county a case is held in. And there could be, and frequently are, more than one appropriate venue. For example, wherever a car accident or a truck accident happens is, generally speaking, an appropriate venue for a particular case. Also, wherever a defendant is located, wherever a defendant lives, is an appropriate venue for a case. And so that's a decision that a plaintiff needs to make early on, is where do I want this case to be held? Do I want to have it held in this county or another county? Some counties just tend to have bigger verdicts, tend to be either more plaintiff friendly or more defense friendly than others. So that needs to be considered, not only which one you prefer, but if the defense files a motion to transfer venue, basically saying you didn't file this in an appropriate venue, I want it to be held in a different venue, very frequently the defense in their motion is going to get to decide which one of these appropriate venues it gets sent to. So whether or not it's a good venue and whether or not it's a venue you can hold is something very important to consider, and is one of the things that can affect the value of the case.